Right now, I'd like to go over our Level 3 Bloomberg report with you. It's going to go over quite a bit from an attorney's standpoint. So if you guys are looking to go and litigate a case, then this is definitely the product that you guys are going to want to take as evidence. All of our reports are going to come out of the office in CFLA letterhead. We do have the ability to private label anything that you order and put it in your company's name. And it's going to be prepared for the homeowner that you have that is going into foreclosure. As we go through the pages, what you'll see are the different parties that are involved in the transaction. Obviously the borrower and the co-borrower, their address that is actually in foreclosure. The transaction participants are going to represent everybody that was present at the time of closing. The mortgage broker, the servicer who the homeowner eventually ended up making their payments to. The nominee or beneficiary is typically going to be MERS. Not 100% of the time, but most of the time you will see MERS named as the nominee beneficiary of the loan. The original mortgage lender, whoever actually lent the money to the homeowner to purchase the home. The mortgage trustee and the title company are typically associated, and obviously those are the people who drew up all the closing paperwork for your homeowner to actually acquire this loan. Now the first page that you guys are going to look at when you are completing your complaint is going to be the securitization participant screen, which is going to give you all the named parties and interests that you're going to highlight on your complaint. The original lender, the sponsor, the depositor, and the issuing entity. These four components here will make up what a proper chain of title should be. So once we go to the chain of title page, you'll be able to see if the loan traveled through a proper chain of title. The trustee acts on behalf of the issuing entity because they are nothing more than a pass-through. They don't have anybody to collect payments, which obviously is the job of the servicer, and they don't have anybody to conduct clerical things or administrative tasks, which is typically appointed to the trustee. Now the custodian is in charge of handling all of the paperwork, the notes, deeds of trust, or mortgage if they actually make it into the trust. The important pieces of this page that you're looking at as well are going to be the cutoff and the closing date. Now, the prospectus will outline what the cutoff and closing date are for this particular trust, and that's important to you because if you're looking at an assignment of mortgage or an assignment of deed of trust or an assignment of the note, and it does not make it into the trust within this cutoff and closing date time frame, which is typically 25 to 31 days, that's a pretty big problem for the trust at that point. Basically, once the cutoff date begins, they are allowed to actually put loans into the trust, and once the closing date occurs, there is absolutely no more notes that can be placed into the trust. Typically, depending on the pooling and servicing agreement, they will be given a 30 to 90 day right to cure, meaning if there is anything that needs to be finalized with any of the loans that they have in the trust, they have a 30 to 90 day time frame to do so. As we continue through the report, you will see on every CFLA report a copy of the prospectus and the pooling and servicing agreement. Now the prospectus has specific language in it that cites that the note and the deed or mortgage have to travel as one unit throughout the debt conveyance process. This is one of the tools that you're going to use when you build your complaint because it's going to outline that specific fact that the note and deed have to be congruent as one unit throughout the conveyance process. It's also going to give you a list of all the named parties and interests that were on the previous page. What we'll do is excerpt the language that is important to you as an attorney, and then provide you with the link to the SEC website where the prospectus was pulled. Now this is important because the prospectus being about 395 to 450 pages long, obviously we're not going to include that entire thing in the report. So the judge can go to the SEC website and verify that this language came directly from the prospectus that correlates to the trust that we have named on the report. Now the pooling and servicing agreement has been referred to as the Bible for securitization. Okay, the pooling and servicing agreement is the contract that the trust would have with the SEC that allows them to take a note and turn it into a mortgage-backed security. Okay, this will outline all the roles of the originating lender, the sponsor, the depositor, the servicer, the trustee, and everybody involved in the securitization chain. So, what you need to look at, a couple of things, is does the servicer have the right to foreclose on the property if they are the holder in due course of the note? This also has to do with the debt conveyance process. Section 2.01 and 2.02, which will always be highlighted in the report, will go over how the REMIC needs to come into existence. Typically, you'll see that a REMIC has to go through 2 true sales in order to become bankruptcy remote. So basically, it has to go from the originator to the sponsor, and there have to be recording fees and taxes paid there. Then it has to be recorded to the depositor, and again, recording fees and taxes would be paid upon that transaction, and eventually it would make its way into the trust. Again, 2 true sales to give the REMIC its bankruptcy remote status. Without that status, the REMIC cannot exist, and the trust is liable for double taxation going back to the inception of the trust. So 2.01 and 2.02 are going to go over that language specifically to tell you what the conveyance process needs to look like for the loan to make it from the originating lender into the trust. Again, this is another document that's going to be between 395 pages and 450 pages long. So the entire document obviously will not be included in the report. Again, what you'll see is the excerpted language that you need to go over that's going to help you build your complaint, and then you'll see the link at the very bottom. That way, again, it can be verified that it came directly from the SEC website. Now, the portion of the report that makes this a level 3 report or a Bloomberg report are the screenshots from what's called the Bloomberg terminal. Bloomberg is proprietary software that's used to track securities, whether it be coffee or gold or diamonds or, obviously in our business, mortgage-backed securities. Now, what you'll see on the first page is going to be the description of the trust and the highlight of the loan being in the trust specifically. The first thing that we're always going to look at is to see if there is a direct loan number match for your homeowner's loan. Typically, we will see a loan number match, then we can verify that the loan specifically is located within the trust by these factors here: the original loan amount, the origination date, the zip code, and obviously the loan number being a direct match. Now, in the instance that there is not a direct loan number match, which does happen, typically the loan number could change once it gets to the servicing bank. The SEC website may have a different tracking number for it. The Bloomberg reporting software may have a different tracking number for it. So the loan is not going to always be a direct loan number match. The other factors that will be searched for would be, again, the original loan amount, the type of documentation that the loan was, whether it was a limited doc or a full documentation type of loan, the geographic location of the property, whether or not it's owner occupied, the zip code, and then the city and state that the home is located in. All those different loan characteristics will be searched to determine that your homeowner's loan is located within this trust. Now, a CUSIP number is something that's associated to all securities. It's basically an identifier that is used to track the security in question. Now, what you'll see is that each group will have its own CUSIP number, and each class will have its own CUSIP number. Also, each individual loan will have an individual CUSIP number that does not change throughout the reporting process. So we're able to identify exactly how many different classes or risk tranches the loan is located in based on the CUSIP number that's associated with the loan. This particular loan will show that it's located in 19 different classes within this trust. Now, the 19 different classes that it's separated or fractionalized into has to do with fractionalized banking. Basically, from a security standpoint, if the trust was going to have Moody's or Standard & Poor stamp a AAA or a AA or a single A credit rating on a group of assets, from a lending standpoint, you would think that only loans with a very high credit score, very low loan to value, and very low debt to income ratios would be stamped a AAA credit rating. Unfortunately, between the years of 2001 and 2007, the heyday of subprime loans, they needed to figure out a way to eliminate the risk of those subprime loans. So what they did was take the loans and break them up into fractions. Again, fractionalized banking. So they would take portions of the subprime loans and mix them in with other loans of better quality, and they would get Standard or Moody's to stamp it a AAA or AA or single A credit rated investment. Now, this shows implications of securities fraud and fraud to the investors because they were not selling a true credit rated investment. What they were selling was a blended credit rating. Now, what you'll also be able to see on this page is the the number of classes or risk tranches that are paid off. So this loan is located in 19 different classes, and we can show that 13 of these classes have been paid. Now that means one of two things. One, that all of the certificates in that particular class have been purchased, or credit default swap has been issued. Another problem with the credit default swap insurance is that it's unlawful for somebody to take out multiple insurance policies on the same asset. You wouldn't be able to do that with your car note, just like they shouldn't be able to do it with a mortgage-backed security, because they're basically insuring at face value every single note in every single tranche that it's located in. So this loan is essentially insured 19 times over the face value of the note. Now, what that means is if credit default swap is issued in any one of these classes, that every loan in that class is paid at face value. So realistically, the trust stands to make 19 times over the face value of every single loan that's located in all these classes. So if you're looking at it from a negotiation standpoint, or once you get into discovery, which should be the ultimate goal in your litigation, is to get into discovery so you can lay your cards on the table. If you were going to go for some kind of a principal reduction and you show that 13 out of 19 classes have in essence been paid off, then you would want to use that as a simple fraction to negotiate a remaining balance and have a new note reissued to your homeowner. That way they can stay in the home and have a proper payment that they could actually afford instead of going through foreclosure. These screenshots are very, very damning to the banks, and they are very afraid of them because of all the different fraud implications that come about by looking at this Bloomberg terminal. Now, the next couple pages that you're going to look at will be description pages of the actual class and groups of the trust. Okay, you'll be able to see what the original issue number was as far as dollar amount, what the current issue is as far as dollar amount goes. The most important part of these next two pages will be this grayed out box here in the bottom. Now, a lot of court systems definitely fraud upon somebody bringing fraud upon the court, and what this shows you is that this trust is still actively performing to current date, meaning that every loan in the trust is still also actively performing. So the foreclosing trustee, by bringing the foreclosure action upon the homeowner in the first place, is doing so because they state that they're the holder in due course of the note. Without actually being the note holder, they do not have the right to sale. This will prove that the loan is still actively performing in the trust. The loan or the note cannot be in two places at once. So that shows you the tangible fraud has been brought upon the court on behalf of the foreclosing trustee. Now, the next page is basically going to give you the collateral characteristics of the loan. Basically what this is what's inside the trust itself, okay? It's going to tell you what types of loans are in it, whether they're conventional or subprime, whether or not they're first lien or second mortgage types of loans, adjustable and fixed rate mortgages, so on and so forth. Now, the last page that you're going to look at from the Bloomberg terminal is going to be the 8K filing or the prospectus filing. Now, this is one and the same as the prospectus that was highlighted at the beginning part of the report. This is just a direct screenshot from the Bloomberg terminal reflecting the prospectus being the same as the one that was excerpted from the SEC website. Now, the next page is going to be a graphic that shows basically what I was talking about earlier. In order for the trust to gain its REMIC status, it has to go through 2 true sales to become bankruptcy remote. So, again, it would have to go from the originating lender to the sponsor, to the depositor, and eventually into the trust. Now, by following this chain of title, the REMIC status allows the trust to be exempt from double taxation, meaning they only have to pay taxes on dividends going out of the trust. They do not have to pay taxes on money coming into the trust. So what you will typically see in the chain of title is that you will have the note go directly from the originating lender into the trust, and they will skip these 2 middle parties for one of a couple different reasons. The most obvious one is a time restriction. Okay, if they only have a 25 to 31 day window for the cutoff and closing dates, then the correct securitization process and recording and paying taxes on these 2 middle parties could take them outside of that window of time that they have to actually get the note into the trust. So what they'll do is they'll go directly again from the lender into the issuing entity, which in essence it doesn't give the trust its REMIC status. So they're claiming to have REMIC status when they really don't. And again, that's a problem. You know, if you were to attack the trust and make them prove that they have the loan on their books, they'd have to open up their books to show that they actually are the holder in due course of the note. Now, if any violations of the pooling and servicing agreement are found within the books of the trust, then immediately they revoke their REMIC status, meaning they would be liable to pay taxes all the way back to the inception date of the trust on every single transaction that has occurred. Literally, we're talking about billions of dollars. So if you really wanted to force the issue, you might be able to get a very serious principal reduction. You'd be able to file a quiet title action, and you would have some pretty serious leverage generated by this report. Now, the chain of title graphic is going to show you basically where the deed or mortgage went and where the note went. And typically what you will see is that the deed of trust will be recorded with the county, and then sometime later you'll see an assignment to a trustee or to a servicing entity, and then you'll see a notice of default, and then you'll see the chain of title or the chain of deed or mortgage possession as it goes through the process of foreclosure. One thing that you need to verify is that the notice of default was not filed before the assignment of the deed of trust to the party who issued the notice of default. That's a problem on behalf of the foreclosing trustee. The chain of note possession, typically what you'll see is, again, it'll go from the originating date directly into the trust. And it'll be on or about the cutoff date of the trust, because that's when, again, they start putting loans into the trust. The report summary is going to give you a brief synopsis of everything that the report is going to cover. So if you wanted a quick Cliff Notes version of what's included in the report, then you would read the summary of the report. It's going to go a little bit over MERS, what MERS' role is. MERS was designed to eliminate the need for assignment of debt. Obviously, it has not worked out the way that it was designed to work out, and MERS has since become quite an issue in the court system. It'll give you different case law that cite MERS's ability to or not to assign debt. Then you'll have a screenshot showing that the loan is located within the MERS system. It'll also give you who the servicer and the investor are of the mortgage, and that's really the very first step in any of our research, is determining who these parties are so we can identify where the loan is located, in which trust it's located. The chain of title, this is a very messy diagram of what the flow of money looks like in today's mortgage environment. Way back when, it used to be two parties involved, the bank that lent the money and the homeowner who borrowed the money. Those were the only two parties involved. And as you can see by this graphic here, there are so many different hands in the cookie jar that it's very, very hard for the trust to actually keep track of who really holds the note. The next couple of pages, again, are going to go over different case laws citing MERS, whether or not it has the ability to assign debt or not. In the last about 6 months or so, MERS has said to the banking system that they will not be named on any kind of foreclosure proceeding. They basically want nothing to do with the foreclosure process anymore because it has become such an issue. The rest of the report is going to go over different case law that's applicable to your case, regarding foreclosure defense. So all these things are going to help you when you create your complaint to actually file against the bank. Now, one of the parts of this report that attorneys are very interested in, obviously without this, it's not going to be admissible as evidence in court, is of course the affidavit. The affidavit is going to go over the qualifications of the auditor who actually completed the report. It's going to go over the different types of training and certification they've acquired. It basically gives you a rundown of why they're qualified to create this report for you. Now, it's going to go over the different identifying factors and how we found the loan in the Bloomberg terminal, either by loan number or by the original amount, the location of the property type, so on and so forth. So it gives you a lot of different indicators on how we came to the conclusion that this loan is still located within the trust. It's going to go over the amount of classes the loan is located in, how many of those classes have been paid off, and it's going to, again, repeat the graphic from one of the pages above where it shows the classes, how many are still active, and how many are paid off. It's also going to go over a little bit of the information that's reflected on the report summary. That way you have a good idea of exactly what you are putting down in your complaint when you go to file your lawsuit. So, like I said at the beginning, CFLA does offer a very broad range of products, from forensic loan audits to securitization audits to these Bloomberg reports, which are far and above becoming, the mainstay or staple in this industry as to what attorneys are actually using for their litigation. We can create and draft all of your complaint packages that will be jurisdictional specific as well as work on a federal level. They will be specific to all the findings that are identified in the forensic and the securitization audits. They will come with a temporary restraining order and lis pendens. That way you guys can actually file the lawsuit and actually start making some headway for your homeowners. We can draft demand letters, validation of debt letters, QWRs, and just about anything that you would need as an attorney to help your homeowners stay in their home. If you have any questions about these reports or any of the products that we offer, you can call Certified Forensic Loan Auditors at 310-432-6301. You can ask for myself, my name is Billy Bowles, or you can ask for any one of the account executives that would be able to help you open up a wholesale account and start ordering our products and services. I look forward to speaking with you in the future, and thank you very much for your time.